Senator Reynolds on that basis.
Thank you. I hope I haven't misled you, Chair. It depends on the responses. Well, good morning, everyone. Good morning, Minister, Mr Longo and team. I'd like to turn the conversation to government trading enterprises owned and regulated under state laws. So in this case, I'm talking about the Gold Corporation and trading as the Perth Mint. And the question actually, so just for some context for my questions, is Senator Smith is actually chairing a Senate inquiry into the operations of the Perth Mint, and a number of issues have arisen which I think raise questions about possible gaps that these GTEs can operate under, somewhat flouting federal corporations law or slipping between state and federal, particularly directors' responsibilities. So what I wanted to ask first is, has Gold Corporation or trading as Perth Mint, have they ever come to ASIC's attention or been investigated or reviewed by you?
Not that I am aware of, but that is really not a full answer. I wouldn't have to take that on notice, I'm afraid.
That'd be much appreciated.
Anyone behind me can.
That'd be much appreciated. Thank you.
Thank you, Senator.
Sorry, can I just double confirm? Did you say at the opening of your question that they're incorporated under a Western Australian regulatory framework?
Yeah, there is.
I think that would mean it's unlikely, but I think we need to be.
Thank you. That's what. Yeah, I just wanted to make sure because that then leads to some of the behaviours that have been exhibited and subject of long-standing AUSTRAC enforceable undertakings and US Justice Department, the London Bullion Exchange, etc., have found far more concern with Gold Corporation than the West Australian authorities have.
I mean, of course, sorry to interrupt you, Senator, but it's possible, even if it doesn't fall within our jurisdiction, that we've had matters referred to us or complaints made to us, so we'll certainly endeavour to find out the answer.
Thank you. Now, they've had some very interesting corporate partners here and overseas. The two ones that stand out are the Euro-Pacific Bank and the Bank of Cyprus, which are very well known and reported anti-money or money laundering, narco-terrorists, oligarchs, sort of money laundering facilities of choice. And they've also chosen to do business with Perth Gold Mint. So those sorts of relationships, are they really the purview of AUSTRAC? And, I mean, would that have any, in terms of who companies are trading with, particularly when they're known money launderers, does that have, for ASIC, is that not your jurisdiction or sort of interest?
I'd have to confirm that wouldn't be our primary interest. We don't, without trying to comment on the specifics of your question, as a general principle, we wouldn't be regulating or supervising entities' choice of bankers and those relationships. If there's money laundering going on or criminal activity going on, then obviously the relevant authorities would have to be dealing with that. That wouldn't be our primary.
Is the director's responsibilities under federal law and also under state acts. So the Perth Mint are currently subject of a thumpingly large enforceable undertaking by AUSTRAC. And as you know, AUSTRAC have also looked at Crown, Westpac and others for similar breaches. So their enforceable undertaking is just for a small period of time under a particular board composition, 3,322 breaches, possible fines for the WA taxpayers of $21 million each, so just south of $70 billion. Now, AUSTRAC in this case decided, because they'd bared their bottom and said, I'm so sorry, we won't do it again, gave an enforceable undertaking, but the taxpayers are still on the hook because they're still breaching the law. They haven't remediated yet. Sorry, that's my non-official discussion. So here you've got a board who has, at that time when they were knowingly, I contend knowingly had these breaches, they were purchasing conflict gold, they were selling salted gold, The US Justice Department was investigating them. The London Gold Exchange had grave concerns about them. They had J5 in terms of taxation reviews, some of the large operations that resulted out of Panama Papers. They were doing almost no know your customer requirements, which was obviously legislated. And then they, somewhat amazingly, introduced a gold token. So it was called the Perth Mint Gold Token, and it comes down a little bit to what some of the behaviours that Ms Court were just talking about. So they launched a gold token that was WA taxpayer guaranteed, backed by physical gold assets. Not enough. They sold more than they had, but that's another issue. And then they launched it on a cryptocurrency network, the Ethereum network. So these tokens could be sold anonymously through their various, highly regarded not partners. And so they did this knowingly. I probably think they were operating as a digital currency exchange without actually registering as a digital currency exchange, and they did know your customer checks at all. They relied on the Euro-Pacific Bank and Bank of Cyprus for their own checks of their own oligarchs and narco businesses. So you've got a board in a relatively small period of time who are making all of these decisions subject to all of this scrutiny by overseas law enforcement. AUSTRAC was working with them, but chose the path of working with them. But as they worked with them, AUSTRAC admitted they actually got worse in terms of corporate behaviour. Now, it seems to me, and this is where I'm coming back, so that's the background because it is a big, and long issue. So when we asked questions as a committee, the Gold Corporation came back and said, it is not feasible for the Perth Mint's current leadership team to comment or speculate on the factors or considerations that may have informed previous decisions by former executives and managers at the Perth Mint. Now, that is an entirely unsatisfactory response to any Senate committee, but it also seems to me that there's either a secret sealed section of the Commonwealth Corporations Act where people who are on the current board, but if the composition had changed, have no liability or responsibility to even go back and read previous board minutes and provide the Senate information. So I'm just wondering, so my first question really is, with your understanding of how, if you were conducting an inquiry or the Senate an inquiry, would you expect it is legally okay for a board to say, sorry, it's not the same board composition as it was 3 years ago, so we're not going to answer your questions?
That wouldn't be a response that would be deemed to be attractive at ASIC, nor would it be regarded as cooperative or helpful to a law enforcement agency. But I think the broader question, clearly we're the corporate regulator and there are literally millions of directors in Australia, yes. But that doesn't mean we regulate each and every activity of a director. So in this case, we don't have any oversight over the Perth Mint. It's just not our... Yes. Now, obviously, the Perth Mint, I'm not familiar with the structure, may conduct its business through a company, and of course, the company has to have directors.
Corporation,
and
yes.
so, at one level, you say, "Oh, that must be ASIC's fault because it's a company and there's company directors." I think that's an incomplete analysis. On that basis, we would be regulating every business in the country and telcos, and which is clearly not the case. So, but the short answer to your question is, I think the current board should be making reasonable efforts to interrogate the books and records of the company and try to answer the questions. But clearly, if they weren't there at the time, they're going to be hampered in asking.
Some of them were, and some of them were.
Is there a final question, because you've gone 10 minutes because of the 5-minute question?
Okay. So my final question, I'm happy for you to take it on notice.
Yes.
But the big issue about this is there a gap because all of this behaviour is well reported, well known for years, hundreds and hundreds of articles, law enforcement actions, but there's been no consequences for the board, there has been no consequences for the company, and they were able to take huge risks because the government let them go ahead and do it, and it was the taxpayer who was at liability. So they had a very valuable product, but they didn't have to exercise the same responsibilities. So I guess my question is, and again, happy for you to take this on notice, but there clearly is a gap where you can have companies like that operate outside of the purview of federal law.
We're happy to take the question on notice. I was just checking with my General Counsel. Somewhere at the back of my mind, the shareholding of this entity is the Treasurer of Western Australia.
It is, yes.
Yeah. So that's sort of relevant.
Yes.
Colleagues,
Thank you, Chair.
Yeah, thank you, Senator. Colleagues, we